Welcome back to Australian Patent News. Today, Stuart Smith will be giving us a presentation on government grants that are available to Australian innovators, and John Baxter will be giving the second part of his presentation on licensing term sheets.
Hello, my name is Stuart Smith, and on behalf of Baxter IP, I'd like to present to you a guide to funding the growth of your business through the use of government grants. What is a grant? It's usually funding from the state or federal government to achieve a specific public policy outcome. For instance, governments believe exporting by small business is good, so they support the Export Market Development Grant. There are also grants for large enterprises such as the Shell Innovation Challenge and the philanthropic grants from trusts set up for specific purposes. There are over 12,000 grants available from federal, state and local governments and the non-government sector, of which, believe it or not, most companies are only eligible for 3 or 4 of them. It provides the opportunity to inject extra cash into your business. It's better than a bank because there is no interest and no repayments. What type of grant can I get? And here we'd like to break this up into 3 sections to make it clear and easy to understand which grant might be suitable for your business. Categorise those 3 sections as the first is the entitlement grant. This grant will be a reimbursement for payments made by your business, requires keeping proper records and completing the correct paperwork at the application time. Examples are the Research and Development Incentive and the Export Market Development Grant, and the Enterprise Connect Tailored Advisory Services. Do the right thing throughout the year and you will receive the expected grant amount. Second section for grants is the merit-based grants. This requires an application before any funding is granted. You must compete against other applicants for limited amount of funding. Usually they have a limited time which you can apply, and often these are known as rounds of grants. There is a small percentage of applicants will be successful and receive funding. Examples are the Textile Clothing Footwear Small Business Grant and the Tourism Quality Grants. The last category are agreed grants. These can be applied for at any time, with usually no cap on the amount budgeted by government to be given to successful applicants. The applicants will have to meet merit criteria and may still be compared with other applicants. However, if every application met the merit criteria, then each would get funded. An example is the Commercialisation Australia grant and the Clean Energy and Clean Technology grants. What is it about a grant that is different from doing the other ways that you fund your business? The same with a bank. You'll have to provide lots of information, provide reporting, really think about what your outcomes are going to be and what you want to do with the funding. Governments have a way of looking at this, and we can break these down into what the applicant will need to know about, what the outcomes that you're trying to achieve are, and how you're actually going to manage the funding of that grant once you get it. Applicants, for instance, will need usually some intellectual property. For these, such as Commercialisation Australia or the Australian Technology Showcase, the federal government, the state governments want to know that when they invest in your business, there's actually something that no one else can go and copy and then just do it cheaper. So intellectual property is always an important element of a grant funding program. Your business structure can be important. There is no correct business structure, but depending on the business structure and the particular grant may determine your eligibility. And another issue is your financial strength. Some grants you don't want to be earning too much. Other grants you need to be over a threshold of income and revenue. Each grant we will have a look at what the particular thresholds are that you need to meet. There are over 12,000 grants available in Australia. You think, gee, that's terrific, I should be able to get one of those. Usually you'll find a business is actually only eligible for about 3 or 4 at the most. So the outcome of what you want to use the funding for, you need to really zero in and find the particular grant that will satisfy what you're trying to do. So we have the export grants. Governments want to see outcomes where there is increased export. They may want outcomes where there is improved employment. They may want outcomes where there is lower carbon emission. They may want outcomes where there is innovation in the development of products and processes. So the outcome that the public policy wants will dictate which grant you're able to apply for. Once you've received the funding, then how you manage it and how the funding arrives will again depend on the particular grant that you have. Some of them will require match funding. You'll need to be able to show that you can, for every dollar the government's going to provide, you can provide $1 yourself. Others you'll need boards of management to make sure. Others will have where the government will like to have an advisor sitting there helping you make sure the grant's managed well and it achieves the outcomes thereafter. What are the benefits and what are the difficulties of doing a grant? One of the rewards, believe it or not, is the actual application process, because it actually focuses you on what you're trying to achieve with the limited funds that you have available. So the application process itself should be not treated as just the paperwork I've got to get in to use it to determine the priorities in your business. Even in the application process, you'll be getting advice from consultants, either in the process or as one of the conditions of the grant. Consultants and service providers will be be part of the funding. You'll often get publicity. There's nothing a politician likes more than being able to turn up at your business in front of a news camera with a big check and talk about how much they're helping your business, and you would be surprised the amount of coverage that gets right across the television news and is valuable in its own right. It will help you produce business and marketing plans, help you work out what you need to do on the business and not just keep working in the business. You'll be forced to goal set. You'll have outcomes in your funding that you'll need to meet, and they will also go to the wider areas of your business as well. Do you have to put any effort in? Yes, you'll have to put effort into the application. You'll have to qualify. You'll have to make sure your businesses tick off all the areas that you'll need to do to satisfy the thresholds for the grant, and there will be reporting at the end of it. But at the end of the day, there will be cash available in your business that will not be repayable, that will really help fund the growth of your business. Just like to take a little bit of time to talk about some particular grants, particularly in areas for businesses that are innovative and are looking to grow their business through the use of government grants. We're just going to have a look at some examples of some of the grants that are available to a business that is looking to grow. First is the R&D tax incentive. This is a major benefit to companies doing innovative work, building products, processes or services. It actually has a 45% refundable rebate. So if you're in a startup phase, that's actually a cash check back from the government. Eligibility is that you need to be turning over more than $20,000 in your R&D expenditure. You need to lodge the application prior to doing your ATO returns, your tax returns for that financial year. There is a number of other rules within it. You'll need to speak to either your accountant or a consultant in the field to ensure that you meet all the requirements of the R&D tax incentive. The Export Market Development Grant, which has been around for many years, is designed to encourage businesses to export their products overseas. So this is a grant that can be up to a reimbursement grant that can be up to $150,000 a year, and it will run for 7 years. Again, there's an application that has to be put in. It goes in at the end of the financial year and has a limited time period of 5 months for you to be able to claim back after the end of the financial year. Very, very useful grant for companies having got past their research and development phase, really having a product that they want to take to the world. The Australian Technology Showcase is for those companies that do have some innovation, an innovative product or service that the government will help them showcase. They'll also help you market part of that with some funding for export activities. Main thing is that you will get yourself put in with a whole lot of peers in your area to be shown to the world as an innovative Australian company. More recently, grants for clean energy have been available, and these are for either businesses that are looking to reduce their carbon intensity or their electricity usage, or for companies that have a new product or service that in turn will help a company reduce their energy requirements. This is a major project with $1 billion going into it over the next 8 years. So it is well worth having a look at this particular grant if you think your business wants to become more sustainable or has products out there that can help other businesses become sustainable. The last one we'd like to look at, which is Commercialisation Australia. This particular grant is very useful for those companies that have developed their R&D and are now wondering how they can actually take it to the market, prove it in the marketplace, or get that funding to get it ready to make a launch onto the world stage. There are 4 areas of this grant. We will look at these in a section on their own, but for companies innovating, it is essential that they know about Commercialisation Australia and take advantage of the funding that's available through it. Thank you for your time today. If you have any questions regarding government grants at all, please contact Baxter IP and we'll be able to talk to you about your individual requirements.
Hi, I'm John Baxter from Baxter IP. I'm here to talk about technology licensing. Licensing your IP to another party can be an effective way to exploit the IP, particularly if you don't have the resources or experience to develop and market your product or service. Essentially, a license agreement is a contract governing the commercial and legal terms under which the IP owner, termed the licensor, gives permission to another party, termed the licensee, to commercially exploit that IP. A license may extend to all aspects of commercialisation, from using the product or process through to developing it further, manufacturing products, and then marketing, promoting and selling those products. Importantly, the licensee has the right to use but not own the IP. The owner of the rights will usually receive payments in the form of royalties in return for use of the IP. In this talk, I'm going to go through the structure of a license agreement and demonstrate aspects of this structure with a few practical examples. A license agreement always first specifies the basic rights being granted to the licensee by the licensor. These rights will have a defined scope in the following areas. Firstly, whether the license granted will be exclusive, sole or non-exclusive. The important question here is whether there will be need for other licensees now or in the future. A sole license is generally accepted to be an exclusive license, except that the licensor also retains commercial rights to exploit the technology in its own right. Secondly, will the right being granted be for manufacturing, usage or sales, or a combination of these three? How will the licensee be limited in how it makes use of the IP? Remember that in the broadest sense, the monopoly provided by a patent is a right to manufacture, use and sell. Thirdly, the geographical territory or territories. In which countries will a licensee be allowed to commercialise the IP? Fourthly, the application field, or a definition of the licensed product and or licensed process is needed. Will a licensee be limited in terms of the types of products or processes that it can use the IP in relation to? Generally the answer is yes, because patent claims by their very nature are written to maximise broadness in the context of existing prior art. Fifthly, you need to define the actual IP being licensed. For example, granted patents, patent applications, registered designs, registered trademarks, common law trademarks, documented know-how and undocumented know-how. Remember that know-how to be licensed should ideally be properly documented and listed in summary bullet form at the very least if this is not possible. And lastly, are sub-licensing rights and or have-made rights going to be granted? The question here is whether the licensee will have the right to license others, and if so, under what terms. Can the licensee subcontract the manufacture of the licensed product? You can see here that it is very important to think of the rights granted in terms of a matrix of these parameters. For example, exclusive manufacturing rights may be granted under a certain set of IP in the US, but non-exclusive sales rights may be granted under this IP for the entire world. IP relating, for example, to a hydraulic system may be licensed for the application of earth-moving equipment greater than 10 tonnes in one territory, and for the application of materials handling or forklift trucks under 5 tonnes in another territory. You can be specific as you need to be here, providing the definitions are rigorous. Such limiting definitions, of course, are particularly important where exclusive rights are to be granted. The message, of course, here is always analyse the rights using a rigid matrix structure, cell by cell, and never grant commercially unnecessary and therefore not valued rights to a licensee. In exchange for the rights granted, the licensor normally expects remuneration from the licensee. The remuneration terms of a license agreement normally at least includes the licensee paying the licensor firstly an upfront license fee and or disclosure fee, and secondly a once-only royalty or a per unit royalty. Sometimes also an annual minimum royalty is specified. If the royalty is a once-only royalty, the payment may be stage-gated. A per unit royalty is commonly expressed as a percentage of the sale price of the product or process being licensed, or as a fixed unit dollar or other currency amount per unit. This is normally indexed in some way to cover the effect of inflation. Again, there are many pitfalls in getting the remuneration terms of a license agreement commercially sound for the licensor, and also unambiguous if they are ever later need to be interpreted by a court of law. Very importantly, you can sometimes win in terms of a foreign exchange gain if you decide to adopt a royalty structure in a foreign currency, but of course you can also lose and lose badly. If you do decide to or driven to a fixed royalty in a foreign currency, always at least provide for proper indexation of this royalty. Come back next week where I'm going to talk about the IP provisions of a license agreement and how we define the term of a license agreement.